Welcome back to HOA Hell. I'm your host, Michael Kushner, and with me today is Senior Associate at MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. How are you?
I'm fine, thanks. How was your weekend?
It was great. Thanks for asking. Yeah.
Good.
You?
I had I slept and I rested,
Okay.
but it was a relaxing weekend.
Good. Glad to hear.
So today we're going to talk about, we've covered some very emotional topics in the last few episodes that we've recorded. Maybe not necessarily released yet, but we covered recently liens and foreclosures and recalls, and these are really heavy topics. So today we're going to take a little step back and we're going to cover something that's a little easier to take. It's a little more vanilla, but it's very important. And quite frankly, it is something for everyone that lives in or is about to live in an HOA governed community, and that is what's an HOA and how do they work in California. Specifically, though, we are going to cover some of the surprises and pitfalls that new homeowners, new purchasers into HOAs end up falling into, and how that happens and what they can do once they are in it. Or if you already are in it and you find yourself, oh, shoot, I didn't know that. We're going to give you some answers and solutions today, okay? So let's start with some very basics.
Okay.
What is an HOA and who runs the HOA? So, Sam, give me a very simplistic but accurate answer as to what is an HOA in California?
Well, in California, Mike, HOAs are common interest developments, residential communities that are bound by recorded CC&Rs, and these are declarations of covenants, conditions, and restrictions.
Okay.
And in addition to that, they own common area. Either the association owns it or it's owned in common by its various members.
Okay, good. All right, so we have a recorded set of CC&Rs, and we have common area that is owned either by the association or by the members, like in a stock co-op, for example.
Exactly.
Okay, and now, most HOAs in California happen to be corporations, and they're nonprofit corporations, okay, mutual benefit corporations. But that's not technically required under the Davis-Sterling Act. They don't have to be incorporated. A lot of lay people and a lot of lawyers who should know better will talk about how it's a requirement that they be incorporated. That's not true, okay? Most are, but it's not required. But with all corporations, profit and nonprofit, they are run by a board of directors. Right. And so your HOA is always going to have a board of directors, and that's true even if it's not incorporated, isn't it?
Either one of those two, regardless of which dynamic.
So tell me about the board.
So they both, regardless of which type, require a board, and these boards are comprised of members within the community. So they have to be homeowners under the Davis-Sterling Act. Okay, and that used to not be the case, but a change several years ago stated all board members must be owners. 100%.
Okay, they don't have to be residents, but they have to be owners, and they run the association, whether it's incorporated or not, right? Okay, now. Talk to me about, when you serve on the board of a for-profit corporation, as an example, you often get perks and you get paid for your time.
Right.
Is that the case here?
No, these are volunteers, unpaid positions, like we said, homeowners who volunteered to get on this board. These are not professionals.
No, these are lay people, right?
Lay people, exactly.
These are the people that live in your neighborhood. The teachers, doctors, lawyers, plumbers, landscapers, retired people, runs the gamut. It's whatever. Whoever runs, and it runs the gamut, just as society runs the gamut.
Just to correct what I just said, they may be professionals in their private lives, but they're not professional CEOs and executives running.
They're not
the
professional board members. Correct. Right. Okay. So you've got a board of directors of homeowners who are volunteers, lay people. Okay. So that's what an HOA is, and it's governed by this board of directors, just like any corporation is, and they're the ones that run the HOA. So let's talk about what running the HOA means. If they run the HOA, then the board of directors has to be responsible for something, right?
Right.
So we talk and we've mentioned in many of our episodes of our podcast, we've talked about the three fundamental, most important, I don't know what other superlatives or adjectives we can use, but there are three fundamental duties that an HOA has. Give me two of them.
Okay.
And I'll feed the third.
Sure. Well, two out of the three would be basically enforce the governing documents and maintain common area.
Okay. So,
which would be, by the way, repair, replace, and maintain the common area.
Right. So repair, replace, and maintain the common areas, I would put as number one, the most important thing they do. That is the most. But slightly behind that, and just as fundamental, is enforcement of the governing documents.
Yeah.
And enforcement of the governing documents not only means enforcing it, against you if you violate, but also if your neighbor violates, and helping you protect your rights because of somebody else's failure to follow the requirements of the governing documents. Governing documents, again, we brought up 4 of them. The ones that you should pay attention to are the CC&Rs, the bylaws, rules, and architectural guidelines, although that could be 3, okay? Those, they have to enforce those. That's just as fundamental as them maintaining, repairing, replacing common area. And another one is kind of a catch-all, but it's still just as fundamental because it covers everything else. They have to run the association itself.
Manage it, yeah.
They've got to hire appropriate vendors to conduct work so that they are caring for, maintaining, repairing, replacing those common areas. They have to hire staff to help them hold people accountable so they can enforce governing documents. They've got to take care of elections, everything. So those are the 3 fundamental duties that a board has.
Right.
Okay, it's a lot of work. Okay, now if the board is not doing all 3 of those, they don't get to pick. They got to do them all. If they're not doing them, there's a big problem because they are not only breaching their fiduciary duty, they're violating the Davis-Sterling Act. And that's a no-no. That's something that they cannot do. So either their failure to do those things, or if they're doing them badly, is not only a violation of fiduciary duty and a violation of the law, but it affects you very, very, very specifically because it will, at some point, directly affect your pocketbook. 100%. Either in the form of increased dues, increased or more frequent special assessments, or even worse, punishment by the FHA, for example. Not, if you have a more than 15%
default or delinquency rate
on fines, FHA will pull their funding for any properties in that community. So that's a big, big problem, okay? So at some point, it'll affect your pocketbook, okay? So now we've kind of covered what are the HOAs and what role does the HOA's board of directors do. Now let's move on to the role of the management companies. So we did a separate podcast entirely on the role of management companies, and there's an article on my website, mbkchapman.com. Just go to the articles tab and find it. It's recent. It was probably published at the beginning of August of 2025. And there's an article on management companies as well as a podcast. So the management companies, as you'll recall, Sam, are serve at the pleasure of the board.
That's right.
Homeowners don't hire them. Homeowners have nothing to do with the management company other than communication with the management company. But management company doesn't owe them any separate duty. Okay, the duty's owed to the board.
Correct.
And it's owed to the HOA.
And that's where the privity of contract
That's where the privity is. That's right. So the management company is not the HOA, is it, Sam?
It is not. Okay. They're an agent.
They're a vendor. Just like the landscaper, just like the painters, just like the
roofer,
or just like the reserve company people, or the accountant or the lawyer, or anybody else that's paid by the HOA to handle one aspect of its management under the care and guidance of the board.
That's right.
Everything starts and ends with the board. The board. Okay? Everything else is vendor. And everything else has no duty to you and no individual privity to you as an individual owner. To the association itself, sure. To the board, sure. But not to you. Okay? Now, and for why that's important, go ahead and watch our recent podcast on the management companies. So, the big problem that arises is when boards let management companies run the show. We covered that. That is one of the biggest red flags. That's one of the biggest issues, because not only does that you have the board handling things or divesting themselves of responsibilities that they should be monitoring, but in some cases they're actually delegating duties that are considered non-delegable.
That's right.
Even if they want to, they aren't supposed to let other people handle it. So you have 2 problems there. One, they're not overseeing. Even on the issues that are delegable, they still need to oversee. They can't just trust blindly.
Right.
They should be checking. But they're also often delegating duties that are non-delegable. Again, for a list of those, go to that other podcast or the article. Just keep in mind, you've got this board of directors that is now helped by a management company. who usually helps as a liaison with all the other vendors.
That's right.
So that these 7 or 5, usually 5, but sometimes 7 individuals, lay people, aren't spending full time on this job that they aren't getting paid for.
Right.
That's the whole point of the management companies and vendors, is to do things that they're just not, the board isn't qualified to do, but they should be overseeing. Okay? Now, let's go back to the governing documents.
Okay.
Let's talk about the difference between the CC&Rs and the rules. We did an episode, I don't remember if it was a short or not. I can't remember. It might have been a full-length episode on the difference between CC&Rs, bylaws. I think it was a full-length episode.
We did both. Yeah.
We did both.
Yeah.
Okay. So we have a separate episode on that. You can go look. But we're going to cover it briefly here. But we're only going to cover those two. CC&Rs, rules. Now, which one trumps?
CC&Rs, 100%.
Okay. And that's the recorded document.
That's a recorded document.
Public
People
record.
have constructive notice. You get those in your escrow documents when you purchase into a community. So, absolutely.
So anything in the CC&Rs, if there's a conflict between the CC&Rs and the rules or the architectural guidelines, which are on the same level as rules,
Right.
what trumps?
The CC&Rs trump.
Okay.
They prevail.
Now, sometimes the CC&Rs will talk vaguely about something, and the rules will go into more detail. Is that okay?
That's absolutely okay. Yeah, they can clarify it and flesh things out.
That's right.
Yep.
Sometimes the CC&Rs will, in fact, one thing that we should probably start with is, unless the CC&Rs authorize the board to create rules, then they can't even do that.
Right.
But I have rarely, off the top of my head, I can't think of a set of CC&Rs where that wasn't in there.
I've yet to see one.
Yeah.
That doesn't.
I know I've probably seen one in my career, but it's been years. The really old set, maybe. The CC&Rs in 99.99, I'm only saying 99.99, not 100, because I'm allowing for the possibility that it doesn't exist. But I can't think of one example off the top of my head. Can't even think of one exception. But the CC&Rs almost always have a line or 2 or 3 that say something along the lines of, the HOA may promulgate rules in the future to govern the association. Something like that. It doesn't take more than that. It's a very simple statement. Very, very broad, very vague. That's enough. Okay? As long as none of the rules that they promulgate explicitly contradict CC&Rs. I'll give you an example. In my association, CC&Rs, they comment on the types of vehicles that are allowed in the community.
Yeah.
And one of the types of vehicles that is not allowed in my community is RVs and recreational vehicles like dune buggies and RVs and conversions and that sort of thing.
And that's a common one, yeah.
Right. Non-street legal dirt bikes, that sort of thing.
Yeah.
Okay, that's in the CC&Rs. It also is in our rules and regulations. Okay, it's both. Our board was talking about doing a rule change to allow certain kind of recreational vehicle in. And the lawyer for our association notified our board you can't do that because it actually contradicts the more broad language in the CC&Rs that says no recreational vehicles. So in that example, that's proving the point we're making here, is that the rules can go into more detail, they can flesh things out, they can do all that. The one thing that the rules can't do is directly conflict with what's in the CC&Rs. Okay? Now, of course, we're going to talk about rules in a second and what their requirements are, 4350 of the Civil Code. But at least with respect to the dichotomy of the two documents. So, CC&Rs are superior in every way.
Absolutely.
They are the Holy Bible. They are the governing document on top of everything else. They are numero uno, the king. Pick your poison, okay?
Sure. Yeah.
Now, CC&Rs, can they be amended by a vote of the board?
Not by a vote of the board. It has to be by, they can be amended. It has to be by that of the membership, and it's oftentimes a heightened standard, supermajority. So
but it doesn't have to be, does it?
It doesn't have to be, but in most cases it is. Yeah.
In most cases it is. Often it's 2/3.
Right.
What that means, whether it's 65% or 72, whatever, it would depend. But most of the time it's not just a mere majority. And most of the time it's, by the way, here's an interesting issue. It's very important to look at your governing documents and in the Davis-Sterling Act when you're looking at voting thresholds, because there is a big difference between a line that just says a majority and a majority of the homeowners entitled to vote.
Right.
If your language, or if the Davis-Sterling Act and 4600, Civil Code 4600 is one of these, when you're talking about seating common area to a specific homeowner as exclusive use common area. That's covered by 4600. It specifies in the voting threshold that's discussed in that statute, it specifies that it's the voting threshold of the entire community. In other words, if you have 100 people in your community, a quorum would be 51, okay? And a majority of the quorum would normally be enough to pass something unless the language says it has to be a majority of the people living in the community, or the votes entitled, the voters entitled to vote, in which case there's 100 of those.
Right.
So to pass that, you would need 51 votes. So unless everybody if you just had barely a quorum, 100% of them would have to do it for it to pass. So there's a big difference between a majority of a quorum and a majority of the people entitled to vote.
Yeah.
So look carefully, because the threshold is that's the minutiae in the details there. So, or the devil's in the details.
And by the way, those standards are typically found in the bylaws. So
yes.
So when you look at the threshold-related numerical standards, look in your bylaws.
Right. And if it's not there, it could be in the CC&Rs about amending. For example, amending the CC&Rs, the provision's often found in the CC&Rs as well, and it'll say a majority of just a mere majority, or it'll say a majority of the homeowners entitled to vote, or it'll say a supermajority, or 60% or more of the homeowners entitled to vote. Just the words matter, so keep that in mind, because that 60% could be two different numbers, okay? But usually it is, you're right, it's a supermajority. But the board can't decide on themselves to amend the CC&Rs. It doesn't work that way.
No.
The rules, however, they can, provided they follow the requirements.
Exactly.
So for those of you who want a refresher, the requirements are, the board will meet and discuss, we need a rule change.
Yeah.
And they'll vote, and they'll have this discussion, open meeting. They'll vote on it, and then they will say, okay, we this is what we propose, and they'll have the current rule, and then they'll spell out the change in the rule, the language for the change. And then there's they have to provide at least a 28-day comment period, during which all the homeowners have been notified in writing, here's the existing rule, here's the new rule that we're proposing. And homeowners have a chance to write in, say, I hate this, here's why, or I love this is fantastic, what took you so long, whatever. Or do nothing and wait till that meeting after the 28 days. It could be on the 29th day, it could be the 30th, 40th, whatever, but at least 28-day comment period. And then at that meeting, they have to afford everybody a chance to come up and talk, because a lot of people will reserve their comments for a live audience. And people will talk, and then the board can listen, and then they go and they discuss it. And they can choose at that point whether to disregard it. Let's say the vast majority of homeowners were absolutely against this new rule. They can choose to disregard it entirely and say, well, too bad, we like it. And then guess what? It's passed. But there's a 10-day window. And if the homeowners get enough petitions signed, or enough people who want to do a veto, there is such thing as a veto, but it has to occur within that tight period of time. And that is but unless that happens, unless a veto is effectuated, the rule goes into effect. I think it's 10 days, upon notice. Okay, we heard what everybody said. The rule is effective as of blank date, and that's got to be 10 days after that meeting. And you're done.
That's the adoption date, yeah.
And you're done. That's it. Okay? So that's how rules get passed. The board really drives that. Okay? Now, the civil code, talk to me about 4350. What are the three requirements?
Well,
the three biggies.
Yeah, well, Civil Code Section 4350 essentially outlines that these rules that are proposed and then eventually processed and adopted,
or in effect,
have to be reasonable. They cannot be arbitrary and capricious. I mean, obviously, there has to be the basis for it in the governing documents to allow the boards to pass these rules,
which there almost always is. So we're going to assume that that's the case, just like we said before.
And that's where we encounter a lot of the issues in these communities where they run afoul of that.
So the rules have to be reasonable, and they can't be arbitrary or capricious. That's the requirement. Now, what reasonable means is an objective standard. It's not a subjective standard. What's reasonable to Sam might not be reasonable to me is not the subject. That's subjective. It's objectively reasonable, the reasonable person standard. So if a court is ever going to look at that, they're going to make a determination is based on the information, what is reasonable to a reasonable person given all the factors that are at play. Boards of directors have a tremendous amount of leeway under the business judgment rule, something we've talked about in prior podcasts, to kind of, rules are considered, it's not a it's a presumption, but it can be overcome. We do it all the time at this law firm. We overcome that presumption all the time. But the rules are given the presumption of reasonableness unless demonstrated otherwise. Mm-hmm. So all you need to remember for this part is the CC&Rs trump the rules.
Yeah.
And if you ever want to find a way to remember that, just remember only one of those documents is recorded in the county. Since that's much harder to do, that's the harder one to change, so that must be the more important one. That's all you got to remember, okay? And as long as the rules are reasonable, as long as they're not arbitrary and they're not capricious, then the rules are binding. Mm-hmm. And by the way, I'll comment to this just so you remember, unless the Davis-Sterling Act is specific, unless the Davis-Sterling Act says something otherwise, any new rule that is passed is retroactive, meaning it applies to you even if you were an owner prior to the rule being passed. So if the rule changes something, it applies to you regardless. Okay. Now, there are fortunately, because that could be very abused, there are fortunately many, many exceptions because the statute makes it clear, or the rule makes it clear. Often the rule will make it clear because you have a lot of rules that they would not be reasonable but for having the language that says this doesn't apply. For example, let's say, you're in a very upper end community and landscaping generally costs $300,000, $400,000, $500,000 or more. And they make a major rule change about landscaping. It is not reasonable. As a matter of law, I can almost guarantee it will not be reasonable for an HOA to go, 180 with new rules and say, everybody rip out what you did and spend another $500,000. No way. Even though there's no statute that says you can't do that. Okay, so part of reasonableness is what's the change and what's the effect of that change. Right. But I'm speaking more along the lines of when California, for example, passed the rule on short-term rentals and rental limitations that were legal, they made it very clear to say that any rental limitations placed on that a board might place by way of rule or by way of CC&Rs are not retroactive to existing homeowners.
Yeah.
Whatever the law is in effect when they purchase is the law for them. Mm-hmm. So if, for example, if your HOA were to change their rules and disallow short-term rentals, which are rentals of under 30 days, let's say your HOA had always allowed it and tomorrow is day 28 of their notice period and they're about to go forward with this no more short-term rentals, but you bought 5 years ago. Not applicable to you until you sell your house. You can do short-term rentals, 3-day, 4-day, Airbnb, all you want. It won't apply to you because the code was specifically not retroactive.
Just one quick note on that specific example, which is a fantastic one. If you were to sell your home, guess what? It does not run with the land because a new owner, subsequent owner, or transferee would then be subject to the operating rules.
Of course, because yes,
right.
Rule changes run with the land as do the legal requirements, of course, because of the legal requirements. They only apply to the current owner, not a future owner.
Yeah.
Okay, now, who owns what and who pays for it? Mm-hmm. Okay? Many disputes stem from confusion about ownership and maintenance responsibilities. Now, we are going to do a podcast in the near future on how maintenance responsibilities typically work in condominium complexes or multifamily housing like townhomes and condos. And we're going to also, and then we'll touch on, to a lesser degree, on how maintenance responsibilities are divided in neighborhoods with single-family residences. Yeah. Although it's usually much easier, it's much more intuitive when it comes to single-family homes because it's pretty clear who owns what.
Right.
I own what I own. I own my house, and I own the land it sits on. I own my roof. I own my walls. I own my windows. Okay, and I own my landscaping, front and back. But I don't own the roads, I don't own the sidewalks, and I don't own the little patch of grass between the sidewalk and the road, okay? It's usually easier to tell who's doing what. In a condo, it's harder, much harder. So we're going to focus on them, of course, but it'll apply to everybody. We're going to do that in the near future. But we're going to touch on it right now, okay? Because there's being the owner of something does not necessarily, although it's mostly the case, does not necessarily equal who has the maintenance responsibility. And vice versa. So, for example, there are many situations where the HOA, for example, let's talk about exclusive use common areas. In a condominium, let's say it's a balcony. Balconies are often exclusive use common areas. They are part of the common area, meaning they're not owned by the person that owns the condo, the unit. They're owned either by the association, or as Sam said at the beginning, either the association or by the members in common, like in a co-op. But often the maintenance responsibilities are transferred to the homeowner that has the exclusive use, not replacement, but maintenance.
Maintenance, yeah.
So just because you own it doesn't mean 100% of the time you're responsible for maintaining it and vice versa. Okay? That's important distinction number one. Also, who's maintaining it might be, for example, the HOA is responsible to pay for and maintain something, but you're responsible to notify them if something goes wrong.
Right.
Okay? So that's what we're going to talk about right now, okay? And a lot of disputes arise from this kind of confusion.
Oh, yeah.
I'd say you meet with people at least once a week, right? You meet with a consult at least once a week where that's an issue.
Yeah. I would even go as far as saying probably daily.
Okay.
Yeah.
And when we run into these problems, do you agree that it's typically much more common in a multifamily housing?
Always, yeah.
Okay.
Yeah.
Much more common, right? All right. So to figure out who maintains, who's responsible for making sure it stays in tip-top condition, that it's cleaned, that it's maintained, whatever that means, repainted every now and then. If it's something wood, sanded and repainted so that it doesn't get dry rot or termites and all that sort of thing, right? Who? Well, where do you go? Where do you go?
The CC&Rs.
Yeah.
Primarily. Yeah.
Primarily the CC&Rs. The rules, it's usually not going to be there.
Right.
It's not really a place for, it doesn't belong in the rules. I don't suppose it's illegal to have them there, but they're most often not there.
Typically, when you see the rules or other types of, let's say, maintenance and repair responsibility matrices, those are there to kind of clear things out, which we discussed. They flesh them out, add detail, but they cannot run afoul of the CC&Rs.
Right. But they're often found, and you'll find them usually as an exhibit or some sort of table.
Yeah, exactly.
A lot of newer HOAs decided to do what older HOAs should have done from the beginning, which was, you know what? We're just going to create a table here. We're going to list all these things: balconies, porches, swings, not sidewalks, but things that I guess people have a handle on. Yeah. Their hand in, like, things that could straddle between a homeowner and the HOA. And they list them all and say, maintenance, pay for it, maintenance, pay for it, HOA, homeowner, HOA, homeowner. And it's just listed there. So if your HOA is in the last 10, 15 years, or your governing documents, your CC&Rs in particular, have been updated, which like many have, there's probably a table or two in there. That's helpful. But if there isn't, it'll be in there somewhere.
Yeah.
Because you have to tell them, you have to inform you guys who's in charge of what, who's supposed to fix that thing, and who's paying for it. That's a big deal because that's everything. Okay.
Right.
So you're going to find it in your governing documents, typically in your CC&Rs. Okay. If you're dealing with mold or water intrusion, that's important to know who's responsible for treating the mold and the water intrusion, who's responsible for stopping it from happening again. Again, that's got to be set out somewhere, typically the CC&Rs. Okay. Now, money, and funding and underfunding in particular.
Yeah.
A lot of HOAs, and again, we did an episode very recently, two-parter, I think. Was it two-parter? I think it was, Reserve.
On reserves? Yeah, two-parter. Yeah.
Two-parter. We went into this in tremendous detail.
Oh, yeah.
I recommend anybody who hasn't listened to that two-part episode, go listen to it. It might be the two most important episodes you'll ever hear on this show. Okay? If you want to learn how to determine whether or not your HOA is financially sound, you want to listen to part one, especially, of that podcast on reserve funds. But a lot of HOAs, I'd say most being more than 50%, are underfunded.
Yeah, agreed.
And boards, that's understandable. I understand the reason. Boards want to keep dues low. Boards don't want to specially assess because they're specially assessing themselves.
Right.
Hey, self, have everybody, including you, write a big check to the association. Nobody wants to do that to themselves. You're not going to vote that to yourself. It hurts. It's not fun. You'd rather spend money on going on vacation or buying a car or buying a 90-inch TV or whatever it is. Okay, but repairs come due, and they come due regularly. If you've ever looked at a reserve study, those things are as scientific as you can get. Okay, in this field, because these are after decades of data collected, it's down to a science. How long in this weather, in our Southern California or in Orange County or this city, how long do these things typically last? What's their useful life? And how much will it cost to repair or replace in the future? Or at least as of today, if you were doing it today, what would it cost?
Right.
That's pretty scientific, how long it's going to last. Now, it varies. You could have good years where you have less dry rot, so a professional might reevaluate and up that number. That's okay. We talked about that. But the when those repairs come due, at some point, everything does, there's got to be money to pay for it. Because remember what Sam said. Sam, the number one fundamental duty, repair, maintain, and replace.
That's right. Yeah.
Common areas. So you got to determine who's responsible for repairing, maintaining, and replacing common areas.
Indeed.
Now,
yeah.
in 99.9% of the time, if it's truly common area, it's going to be the HOA. The exception being exclusive use, and then how far does that maintenance go? Often it's just maintaining, but not repairing and replacing. Okay, so often maintaining will be the homeowner, but repairing and replacing could be the HOA.
Right.
But again, what does the governing document say? Okay, in recent years, we've seen a massive uptick to the point of almost a disease or almost a serious. I mean, what's worse than serious problem? Epidemic of massive special assessments in California.
Oh, yeah.
Special assessments are those assessments where HOA says, hey, everybody, you need to write a check for X amount per home. We need $12 million, and there's 400 homes, so we want every one of you to give us 35 or 40 grand, whatever the math is. Do the math in your head. I don't know. Okay? We've seen a lot of these major special assessments beyond $25,000 per household. That's literally write a check right now. We got to fix this. That's a big stress inducer problem. Right. Even there are a lot of people retired without fixed incomes that cannot afford that. Yeah. And it's mandatory. It's an assessment. They have to pay it. Right. And why? What changed recently?
Well, mainly the balcony laws.
The balcony law.
Right.
California's balcony law. One of the first podcasts we ever did was the balcony law. There's an article I did after that on my website. Go read that. Go watch that. The balcony law, which kicked in, technically, the big matzo ball part of it kicked in January 1st of this year. Yeah. So here's the thing, people. Those balconies have to be safe. They have to be inspected by the professional, and they have to pass muster. And the HOA is liable if they neglect it. And we're talking massive liability, so they're doing it. And that means all these balconies that have gone years, and they're almost always made of wood, they've gone years and years of systemic failure to maintain, because it's easy, when you build it, it's easy to forget about it for a decade or so, because these things are built to last. So I don't have to worry about it. And instead of saving just a couple $1,000 a year, and for the long haul, oh no, we need the money elsewhere, I don't want to raise dues. So they skip it, and all of a sudden it's been 10 years, and now they haven't done any maintenance, and bam. And then another few years, if they still didn't do anything, now you've got rot and termites. And then you get into the situation where people can die, like in Berkeley.
Yeah.
What were you going to say?
Well, the other incidental effect of these balcony laws is people have taken the microscope to the association's finances and reserves. Yeah. Because these massive special assessments kind of promulgated folks wanting to educate themselves. What's going on? Is there misappropriation? Is there substandard maintenance and deferred maintenance for many, many years preceding that?
Right.
So they have taken that, microscope and either gone for legal consultations like we see, or on their own educating themselves, or coming to places like our podcast to see what obligations do these HOA boards have? Where are they derelict and are failing? And what do things like this reserve study, what kind of information does this give
And that's
us?
The thing. Yeah. Even if, and you're bringing up a lot of people, this microscope has raised a lot of other issues and brought to the forefront problems that people would never have maybe landed on, that we're here to educate you about. But let's pretend there aren't any of those. At the very least, what this has brought to the forefront is how seriously and epidemically underfunded so many HOAs are. Yeah. And so that's why those reserve studies that we talked about in our 2-part reserve study episode are so important. And that's why that percent funded number is so critical, because that percent funded number is a bird's eye view of the health of your HOA. And remember, there are national associations out there that say, look, don't worry if you're in the 55, 58, 60%. I think that's insane. Anything under 60% is a big problem. If your HOA is in the 50s or lower, that is, in my opinion, an emergency, and the board needs to either be fixing what prior boards have done or get that board out of there and get somebody else in. That's what I say. Okay, if you're in the low 60s to mid 60s, pay attention. I would start to be concerned, but I wouldn't. It's not worry time yet. If you're mid 60s to high 60s, I think you're fine. If you're in the 70s, you're good. Yep. If you're in the 80s, you are phenomenal. Even 81%, phenomenal. So I would use that as a guide and not the less conservative guide that the major associations use. I'm here to look out for your best interests, not to avoid a panic. I'm not here to prevent a panic. If it's time for a panic, panic. Okay?
Yeah.
So most HOAs in California are underfunded. Many HOAs in California, way too many, are drastically, frighteningly underfunded. They are in the 50s or lower. We've seen as low as late teens, but that's just, to me, that should be illegal. Okay? I think the Davis-Sterling Act should have a floor. It doesn't yet, but it should. All the Davis-Sterling Act says is the HOA has a fundamental duty to maintain, repair, and replace common area, and they have a duty to assess whatever amounts of money are necessary to accomplish that goal. But it doesn't say, and if you're under X percent funded, you're in trouble. It should.
Agreed.
It should.
Yeah.
Okay? So that's why those reserve studies are so important, because that money has to be there. And if it's not there, you're underfunded. And I'm not talking about, I saw a recent conversation from a lot of ignorant so-called experts. This was on Reddit recently.
No.
I was looking at some of the HOA subreddits, and there was this huge discussion and argument back and forth. And I was just reading it for fun, about, they were giving the roof as an example, and they weren't taking all of the significant assets of the corporation or of the HOA.
Okay.
All of the components, the major components. They were just taking the roof, like, oh yeah, the roof's underfunded, but everything else is fine. No, that's not what the percent funded number is. The percent funded number is a look at the entire association. If everything's funded properly, but the roof itself is 30% funded, but everything else is in the 60s or 70s, who cares? All right. That won't be a big deal. It'll be a minor special assessment, no big deal. You see the multi-million-dollar special assessments, which are then divided by all the homeowners, so 30, 40, 50 grand a piece. You see those when there's a systemic underfunding of the entire HOA, which is most of the components. That's where the problem exists, okay? So now let's talk about what to look for before you buy into an HOA, hopefully, or if you've already bought, what to look for after to clue you in on whether or not there's a problem,
Right.
okay? These are things you should look for to determine whether or not your HOA has a handle on things. Number one, look at your CC&Rs and your rules. Are they outdated? Do they include provisions that, and you can learn this through reading my articles or listening to my podcast, that are illegal under the Davis-Sterling Act? Things that, by the way, in many times when the legislature amends the Davis-Sterling Act, they actually require HOAs to modify the governing documents, right? To conform with the new law. A lot of HOAs don't bother. If your HOA is one of the ones that doesn't bother, it means that they've got an ineffective management company or ineffective attorney, or they're ignoring the management company or the attorney, or both. Either scenario is a problem. So if your CC&Rs or rules are outdated in that they do not conform with current Davis-Sterling Act laws, that's a problem for either of the reasons we just explained.
Right.
Another one, look for the reserve study. California law requires it every how often?
Every 3 years.
3 years.
It's huge.
So, and a reserve study summary every year with all the disclosures that have to come out. We did a separate podcast on that.
Right.
If you go back, if you ask, for example, under 5200, you do a document demand and say, I'd like a copy of the latest reserve study. It's 2025, right? And that reserve study is dated 2021, we have a problem because that was more than 3 years ago. Okay, 2, 3, 4. There should have been one in 2024. We should be on year 2 of the latest reserve.
Right.
So if there's no full, complete reserve study, your HOA is not only violated the law, there's a reason why they didn't do it.
Yeah.
And it's because they don't want the results to come out because something is seriously wrong. That's a huge red flag. So you look for that. Also, one of the things that's supposed to be disclosed is litigation.
Yeah.
Pending litigation against the HOA. When you are buying into an HOA, you're supposed to get a bunch of documents. You're supposed to get the CC&Rs, you're supposed to get the rules, regulations. You're supposed to get the latest that year's disclosures regarding, well, all the disclosures. You're supposed to get all of them. And those disclosures include a list of pending litigation. Now, if there's one lawsuit against your HOA from a homeowner about this or that, no biggie. But if your HOA has multiple lawsuits against it, that's often an indication that something is wrong. Either that the board has a tin ear and isn't listening to its own members, or they're led by people to do things their own way because this is my fiefdom and I will run it the way I want, or your board is inept. It's one of the two.
Yeah.
Because one is no problem. Maybe two if it's a really big HOA. But more than that, yeah, there's a fire. It's not just smoke. Would you agree?
Absolutely, 100%.
Okay. So, selective enforcement.
Yeah.
Talk to a few people in the neighborhood before you make a decision to buy. Okay? Talk to a few people. Hey, how's our HOA board? How's our management company? They listen? When you have something going wrong, are they responsive? Do you like our board members? Have you ever been to a meeting? If they say, no, I've never been, go find another neighbor. People are usually happy to talk, okay? Find somebody that's been to a meeting or two and let them tell you, yeah, the board's receptive, they're responsive. If you hear no, we have some real personalities, or or if you hear that there's been, like, the president of the board served for 15 years, that's right there. That's a red flag. Yep. Does it always mean a problem? No. Sometimes you have a really good person and everybody loves them and the person likes to serve and they do a smashing job. We've seen lots of that. I have. Okay? That's not always a problem, but it is a red flag. It is always a red flag. It doesn't mean it translates to a problem.
Right.
But that's a red flag. If you have board members that have served for a long, long time, that's a problem if that person isn't the right kind of person. And unfortunately, a lot of people aren't the right kind of person. So when you have people that have served for a long time, and it's always a red flag, but it's often a problem. Even though we've seen examples where it wasn't, I would be very cautious about that. Again, each of these factors should be determinative by themselves. Well, the percent funded, yes.
That's a huge one,
okay?
Yeah.
The lack of reserve study, yes. But this one, selective enforcement, maybe not. Depends on the board. But find out whether or not there's egos on the board that kind of retaliate against certain homeowners to speak up. Do they go after a certain group or a certain individual or individuals for speaking up? If so, you don't want any part of that association, okay? Management company issues, same kind of questions. Hey, are these guys responsive when you write to them? Have you ever had an issue we've had to write, and did they respond back within 24 hours? If there's an emergency, do they address it? That's much more important in a condo situation than it would be in a single-family home situation, but still important, okay? If you have already purchased and you're living in this community, these are questions you want to get answers to and then make changes if you're not happy with the answers. It's too late for you. You bought, okay? If you want to get out and sell, great. But if you don't and you want to make changes within, and certainly that's a good way to go, you can do it. We've talked in many episodes about how to do that.
Yeah.
We've talked about how to organize your fellow homeowners. We've talked about how to make those numbers count. We did a show on recall petitions, how to recall your board. And there's an article on the website, how to recall your board. Okay? So we've covered all that stuff. There are so many ways you can make changes. The bottom line is, before you buy into an HOA, if you're contemplating it, you want to get some details and you want to get some information. If you follow the guides I gave today and you go seek the information out, you'll have a pretty good idea about how smooth your life's going to go in this HOA. And if this HOA presents any real problems, if that percent funded number's low, or if there's no engagement by the board, or they're ruled by fiefdom and by unreasonable ego-ridden people like so many HOAs are, you don't want to buy into that HOA because you're going to be buying a problem. If this HOA doesn't know how to manage its finances in a fiscally responsible way, you're going to be paying a lot of money. If the HOA looks like the common areas look like they're not well taken care of, that's a huge red flag. You're going to run into problems. You're going to be paying money. You don't want that, because not only will it cost you money out of pocket, you might find that you can't sell your unit, or that it's very hard to sell your unit. Either way, it's going to hit you in the pocketbook. If you like this episode, please remember to hit the like button. And if you haven't already subscribed to the channel, HOA Hell, please do so. If you have any questions or comments, please, we always like to read them. Leave it in the comments section. Until next time, have a wonderful day.